but I'm happy to be here to discuss this case.
So I'm Dan Schweitzer with the National Association of Attorneys General. We are the professional association for the 56 state and territorial AGs. The AG community files a lot of briefs in the U.S. Supreme Court, different collections of states. The association itself doesn't, but in this case, 19 states, led by Florida, filed an amicus brief supporting the United States. So we were one of only 3 amicus briefs on that side of the case. It was a fairly lopsided, I think, collection of amicus briefs here. In terms of what I think is going to happen is, I sort of agree with the conventional wisdom. It's not looking great for the government, I don't believe. I think 7 justices pretty much seem to show their hand, and of those 7, it seemed to be a 5-2 vote for the government. The 2 that didn't seem to show their hands, well, one, of course, is Justice Thomas. And Justice Thomas on Fourth Amendment issues sort of goes back and forth. He's often the swing vote, which is an unusual place for him to be. So it's hard to judge him. And Justice Ginsburg didn't really show her hand that much. I think going in, most of us would assume she's going to end up supporting Carpenter, and on that assumption, I think it's looking pretty good for his side of the case, either a 6-3 or 7-2, though one never knows for sure. In terms of some highlights of the oral argument, I think both advocates were terrific. That's no surprise on the government side. Michael Dreeben is, maybe the nation's premier appellate attorney on criminal law matters. He's argued over 100 cases and was superb. I think Nathan Wessler for the HOU was terrific, and for a first-time advocate in the Supreme Court, I thought he knocked it out of the park. I guess a highlight for him, I would say, was when Justice Alito was pressing him very hard about how do you distinguish bank records, credit card records, and the like. Why is this, the record issue here, more private, more troublesome? And I thought he handled that very well. From Michael Dreeben's side, what I think I'd highlight is his opening. Opening is that one shot at oral argument where you get a chance to frame your case, and I think he really set up his theory of the case and never retreated from it and really fell back on it. And what he said is the technology here is new, but the legal principles that this court has articulated under the Fourth Amendment are not. The cell phone companies in this case function essentially as witnesses, being asked to produce business records of their own transactions with customers. That was his opening, and that was really his way of distinguishing cases like Jones and Riley. It was his way of explaining why the third-party doctrine, has some reasoning and some sense behind it, and he really, stuffed through that through 40 minutes of very hard questioning.
And let me just add really quickly, I forgot to mention, I do agree with Elizabeth and I guess most of the panel so far that I think that Carpenter has the better of the sort of vote count at the moment. I jotted down at the end of the argument a quick note where I thought, just as an absolute guess, I said 6-3, thinking, but in particular, I think, given the reactions I saw during oral argument, that there's a good chance that Chief Justice Roberts tries to sort of take the reins and build a consensus around an opinion, kind of like he did in Riley. So that's my little prediction. On just a quick note on the advocacy, I agree that Nate at ACLU, especially for a first-time arguer, but really for anyone arguing for the court, did a tremendous job. And in particular, I found an exchange he had with Chief Justice Breyer really impressive, where Justice Breyer was basically saying, look, I'm on your side, but I'm concerned about the potential implications here. Aren't the lower courts going to sort of run amok if we issue an opinion? And I think Nate came back very successfully and said, well, you have a small handful already of circuit court opinions struggling with this, and there's 20 different opinions written, in dissent, concurrence, et cetera. So the courts are already asking for your advice, and the case is here if you have to decide it. So I thought that was really good.
Yeah, it's already a mess, so, why not do the right thing, I guess.
Yeah, I think I would put my money on Carpenter prevailing in this case as well, although I don't believe this is the sort of thing that betting lines on in Vegas. Sadly, maybe for some of us who can predict in advance. So something I thought that was notable during our arguments, multiple justices, especially Breyer and Alito, seemed to struggle where we would draw the line if we say that privacy rights for some things like location trump the third-party doctrine. Specifically, Breyer said during all the arguments, is this the right line? How do we write it? I have less trouble for location that might indicate where he's going to land in this case. but where is it going? So I would like to start by taking a talent and basically plagiarizing Justice Breyer's question. What is the standard that the court should set for deciding this case? Should it be location information generally, metadata generally? Should there be some sort of rule based on connection to electronics or to necessity of the item or action in question? What's the right standard?
Yeah, I think that's a really, I think Justice Breyer keyed into a really central question in this case, and to me it really seemed like the question the court was struggling with. I heard a lot of exchanges at oral argument as being about how they decide the case, not about what the outcome is. It seems like there are votes there to overturn just a blanket adoption of Smith versus Maryland, or extension of Smith versus Maryland to location data. And even really it seems like there are plenty in favor of saying, location data specifically is sensitive. The judges seemed to kind of grapple with how they can explain that consistent with a decision like Miller that talks about bank records. But I think the narrowest version of the rule would just be, in this case, there's 127 days of location data, kind of like the concurring opinion in Jones, and say, this is clearly something that individuals have a reasonable expectation of privacy in, both either just location data specifically, or even more specifically, I guess you could say, location data about cell phones, since Chief Justice Roberts made a point of, pointing out those individuals' dependence on cell phones, citing to his own decision in Riley, their sort of important role in social life, which was addressed both in the merits briefs and in a number of amicus briefs. Or even, I think one of the justices mentioned in some of the back and forth, the connection of the cell phone to the body, the fact that it really reveals something about the person. I think Justice Sotomayor mentioned, the idea of, secure search and seizure and security of the person, and how you're essentially being tracked. So I think that's the narrowest iteration of it, either something about location specifically or the connection to the person, some combination of, the use of the cell phone, the lack of willing transfer of information, something surrounding there, I think is the easiest line they can draw.
Then it raises the question, so you say 127 days is no good, and it's a rule specific to cell site location information. Then the question is that all you say? And then it leaves another case for 30 days, another case for 60 days. I get the impression they don't want to do that. So they do want to get something more concrete. What was interesting is that the ACLU, Carpenter says, we'll give you a day, and that's a proposed rule. And Chief Justice Roberts is then asking hard questions of Nate Wessler, saying, why a day? Under your principle, it should be, it's no good, period. To which he's saying, well, we'll take that too.
Sounds good.
Yeah. Yet Justice Ginsburg's first question was, well, maybe it shouldn't be one day, but if this was a series of robberies that took place over 8 days, then maybe you could get the cell phone information for those 8 days, or at least the hours of those in those days or around the robberies. So, I don't know which they're going to choose, but I think that's really where they're going to struggle to say, is it 24 hours? Is it 24 hours that can be divided over 8 days of the robbery? Because it's not it's easy to say, well, so it's 3 different bank robberies, so you can do 3 hours a day for those 3 days. But what about if it's narcotics transactions that are going over weeks and the need is more than just these discrete incidents? So again, I don't have a prediction for that, but I think that's really where they're going to be struggling to come up with what they think is a workable line that maybe still lets law enforcement get for those couple hours where, just there's a bank robbery, let us see for a few hours.
Yeah, I think you're right that we might be surprised by a ruling that doesn't draw a line neatly and tightly around a particular protected area. I think a lot of us, after the Riley argument, Riley, as you all probably know, is the 2014 case in which the court said that cell phone searches are searches under the Fourth Amendment, and you generally need a warrant in order to look at information on a cell phone. And I think a lot of us after the argument were like, oh, there were 2 consolidated cases, and thought there would be this narrow ruling, or maybe the facts of one would allow them to have a narrow ruling in that case while stating the general principle. And Chief Justice Roberts wrote what I consider to be a very broad opinion, kind of stating the principle that cell phones are ubiquitous, Fourth Amendment privacy interests apply. In fact, apply very strongly, since now we pretty much walk around with like our most private information about almost all aspects of our lives on our phones. And so I think we might get something similar here. It's certainly possible. And I also think that there is maybe not 5 justices, but there's a distaste for the third-party doctrine, I think, in this context. You know, certainly Justice Sotomayor questioned it in earlier cases about whether or not the idea of voluntarily turning over your information even is relevant in the digital age when we kind of don't really have a choice. I mean, you know, I don't know how to not, other than turning my phone off, which I don't even know if that works, but I don't know how to not use cell phone pings to, I can't do anything about that. And I think that that makes some of the third-party voluntariness kind of not make sense. And then for the originalists on the court, you know, there's nothing in the original meaning of the Fourth Amendment that requires a third-party doctrine. It's just something created by the courts to try to suss out what's an unreasonable search or seizure.
So following up on the relation to Riley, several justices noted, and the government actually conceived or announced that cell phones are pretty much a ubiquitous part of modern American life. And what I thought was a very important moment, Justice Roberts cited Riley and said that we should treat cell phones as a necessity, not a voluntary choice to have a cell phone. So, Elizabeth, do you agree with this view by Justice Roberts? And if the court takes that view in its opinion, saying that, you know, not just for Riley, but more generally, cell phones are a necessity, not a choice, how significant is that?
I do agree with Chief Justice Roberts in that case and in that example. And I think it's very important, one, for the third-party doctrine, which we just talked about briefly, but also just more generally when you think about the purposes of the Fourth Amendment. You know, as a progressive text and history person, one might say a progressive originalist, we do exist. Maybe there is just me, but there are probably a dozen of us. You know, you look at the words of the Fourth Amendment, and it talks about the right of the people to be secure in their liberty and their belongings, which is distinct from other parts of the Constitution, which talk specifically, like the Fifth and Sixth Amendments, about persons or the accused, the individuals. And that makes a difference, because it's not just about the way that the government surveillance relates to an individual, though that, of course, could be inappropriate and unlawful and a violation of your Fourth Amendment rights. But it's also the way in which an unreasonable search or seizure by the government generally changes the relationship between the government and the people, something that was a basically term of art for the drafters of the Constitution and the Bill of Rights. And so I think that Justice Sotomayor hinted at this earlier when she said that types of electronic surveillance that allow the government to, from such a distance and so easily amass huge amounts of personal information about you, could result in a change that is inimical to a democratic society, could change the relationship between the people and the government. When you have something that has, as Chief Justice Roberts said, become such an important part of your life, basically something you can't opt out of. You can't really opt out of having a cell phone anymore. And then when you have the ability of the government to basically use that necessity to get perhaps all sorts of information about you, where you go, which might have suggestions of political beliefs, religious beliefs, intimate relationships, these sorts of things that we consider to be at the core of private liberty, then I think that really does make a big difference. And I think that the justices will recognize that. And I think it will be important for not just this case, but all cases that bring up potential government surveillance in the digital age.
Yeah, I totally agree. I think that it's very significant that, especially that Chief Justice Roberts was the one to point this out, to refer back to Riley. I think it goes directly to this issue of, you know, the voluntariness factor that's discussed in the Smith versus Maryland decision, or the sort of idea of assumption of risk that was kind of built into that decision, that, you know, people are, oh, what you voluntarily convey to someone else, that was kind of the premise at that point. I think it's interesting to compare the analysis to a case like Kylo, where the argument was basically made by the government on the other side that, well, you're conveying this heat information out into the ether, right? And the government is just picking up on that, but Justice Scalia rejected that. I also think that it's, again, significant that it was Chief Justice Roberts who was sort of taken by this new role of the cell phone in daily life to draw a new line in Riley where before they had allowed warrantless searches incident to arrest, and he said, no, with this device, this technology as it stands in its role in modern life, you need to get a warrant. And I think he showed his hand a bit. Dan mentioned earlier in his questioning of Nate Wessler, there was an interesting exchange that I'll just read really quickly on this point also later in the argument, but still during the ACLU's portion where Chief Justice Roberts said, a lot of what you're talking about and a lot of what the questions concern, I think, is addressed under the question of whether a warrant should issue as opposed to whether a warrant is required. Under current practice, when you're getting a warrant, it makes a difference if you go in and say, I want to search the entire home or anything I can find, and if you say, I want to search the drawers or business records I think are related to this or that. So basically he's saying, well, a lot of what we've talked about in the line drawing phase, we were talking about in the last question, actually could be dealt with at the reasonableness scope of the search phase in a warrant inquiry, which I found very interesting because it's almost like he's moving past the question about whether this was a search to the question about how would kind of a warrant requirement apply to location data. So.
Which is fine, except when police are, say, told by a witness that so-and-so was involved in the bank robbery, and it's not probable cause yet. It's not quite a reliable enough witness, but you'd like to investigate and see, well, let's see if this person really is a good candidate, was likely to have been involved in the bank robbery. So you think maybe a good way to find out would be to get the cell records for that day and see if actually the cell records show he was near the bank. And if it shows that he was 100 miles away, he's not involved. So now law enforcement is sort of stuck, and it's a tool they no longer have to inculpate or exculpate that person, again, to then take you to the next step where you might have probable cause to get further information. So these things aren't costless. And, of course, the ACLU was saying 24 hours, and so maybe that would still be able to get the information in my example under that rule. But the rule that Chief Justice Roberts is seeming to be pushing of, well, just get a warrant and all of this is solved, I think maybe selling law enforcement's needs a little short. In terms of necessity, again, it is critical that it was Chief Justice Roberts who was saying this. I think Michael Dreeben's response when that was sort of presented to him is, well, we don't really think when we transact with a bank that it's voluntarily handing you my banking information, or the credit cards are sort of a necessity these days, but when I buy things with credit cards, the stores I buy it at, my credit card company has my information, and it's established practice that law enforcement, when they're involved in a criminal investigation, can do a third-party subpoena for it. So it's not really a way of distinguishing existing, that sort of information that the government can currently get. The fact that it's not really voluntary, our use of cell phones in modern society. Again, maybe that's a reason to question the third-party doctrine to the breadth that it's now been given. And a little later, I'll talk a little bit about why I think there's some reason to think that it makes sense. But it's, again, not necessarily the way to, draw the line here as compared to past matters that have been subpoenaed.
Yeah, I thought, not only as you all said that the litigators were excellent in their arguments, but the justice itself, I think, displayed an impressive improvement from where they were just 3 years ago in Riley in understanding this type of technology and its role in society. But I was a bit disappointed that there was virtually no types of discussion about how this type of information via long-term location tracking can reveal sensitive information. And we ourselves so far really only talked about these kind of examples, location at the bank that gets robbed. But I'd like to at least touch on what types of sensitive but not illicit information would be gathered by tracking in Americans' movements over a long period of time, here several months, but even, if we're talking about a couple weeks. So, Alan, could you take us off on that question?
Sure, yeah. I think it's interesting also just to note at the outset that it's almost the reason they didn't talk about it almost is because they just assume, it's almost they all accept the assumption they talk to the implications, to the next implication. Well, isn't it just as sensitive what purchases you've made or what numbers you've dialed. But I do think there's kind of like an underlying assumption, unstated assumption they weren't making that was, I think, voiced somewhat by Justice Sotomayor in her Jones concurrence, also just in the Jones case itself, that where you've been reveals a lot about you. And this even goes back all the way to the beeper cases in the 80s. And I think Justice Sotomayor made the point that if the phone, if you have your phone next to your bed at night, and therefore you can know, anyone reading your location logs, especially over time, can know where you're sleeping every night, then why is that somehow less invasive than the Caro beeper case, where the court basically drew the line between a beeper in a car on a public road versus a beeper in a car when it pulls into your driveway and parks at the home at night and stays there for a certain amount of time. So I think that's like the most basic form of information, the most intuitive. But I know there's been a lot of great work done by interdisciplinary groups and different folks, including some of those that wrote amicus briefs, to show what really can be revealed by just basic analysis of the data points, not only where someone lives, where someone works, but also where they go to church, or the frequent contacts, what medical services they seek. There's just a lot of interesting analysis that can be done with these sets, where you take the data not really knowing anything about the people and use the data to reverse identify people in all different facts about their lives that, as you point out, are non-criminal facts that can be revealed by all this data. I think at one point in the case, as it went up, and including, I believe, in the government's brief at the Supreme Court, they sort of try to make the point that, well, what was introduced at trial was only these 2 pages, and it was only about these specific moments in time that we were looking at. But of course, the data that the government actually obtained was much more extensive than that. It was the full data set. I think they make the point in the ACLU brief early on, and they count out exactly how many individual data points there were. And one thing that Nate mentioned, reiterated several times during an oral argument, was the fact, and in the briefs, was the fact that at the time that this data was collected in this case, because obviously it takes many years for the case to wind its way up to the court, you're dealing with data points in connection with phone calls. But increasingly, people have smartphones and with active data where you're either getting text messages or emails all the time, and so there are transactions, in that sense, communications happening between your phone and the cell towers constantly, creating more and more and more logs. And so the sort of density of the data collected is going up exponentially, and as Nate mentioned, also the density of the towers is going up exponentially. So whenever there's concern voiced about, oh well, I think Michael Friedman made this point a few times, that, well, this isn't GPS data. I think the court was appropriately skeptical of, okay, well, maybe in this particular case it wasn't like GPS data yet, but inevitably isn't it just going to get more and more accurate? So I think that they kind of acknowledge that fact.
Yeah, I think that the justices, and frankly probably all of us, get a little wigged out whenever the government surveillance touches on sex, religion, politics, probably medical privacy. And by being able to track your phone over 127 days, as opposed to just maybe 2 days, you can see important things like where you are sleeping at night, which if you only have 1 or 2 days of data, that might not be that big of a deal. But if someone's spouse is spending every other day at this particular location overnight, that could suggest that he or she is having an affair. Similarly, if you go to the area where the socialist political party meeting is held every Wednesday night, then they might be able to tell that that's your political activity. Or if you go to a certain mosque, or if you go to a certain place where there is medical treatment, they could be able to tell a lot about your life. And so I think that that's important to why the justices are concerned about this broad scope of information, as opposed to the sort of short-lived bad technology beeper, where getting information about someone over the span of a day or 2 days even is very different from being able to look at a several-month period and putting together from each tile of information a mosaic that leads to a picture that really tells you a lot about that person's life.
Yeah, the only thing I was going to comment is something Alan touched upon, is the interesting time lag you have in these cases. So here we are in 2017, and we're dealing with the technology that was used in 2010 and 2011. And so you know, the government quite effectively in its briefs has 2 pages. They have pictures of the half-mile or 2-mile. I think it varied from about a half-mile radius to 2 miles that were covered. That, you know, we knew based on, you know, his use of the phone that it went from a particular cell tower, and so it was within a half-mile range or a 2-mile range. And so they show the map and shows the streets, and there were over 1,000 buildings that were in that, I forget which of the ranges the picture showed, but within that 2-mile range. They pointed out there's a dozen houses of worship, lots of businesses. So on the one hand, you could make the argument that, well, under the 2010 technology, you could make some inferences about what they were doing, but you don't know really where they were going. You just knew they were in that general vicinity. Now, to be fair, I suppose if you look at night, you could tell, well, are they in their home? Is their home within that 2-mile area, or are they somewhere else? What one might infer from where else they are is hard to say. But of course, we're in 2017, and we know the technology has gotten much better. And so what is the court supposed to do about that? Do they decide this case? I know one of the later questions gets to this a little bit, but do you decide this case and say, well, what the government did was a search, because under today's technology, if you tried to do the same thing, it would reveal such personal information that I think it's a search. And arguably, that's not really what the court should be doing. They should be looking at whether what happened in 2010 was a search based on the information they got then. But it is a bit of a bind, and it is tough for us on the ground who are trying to figure out what to do and, say, protect our current privacy or make judgment calls as law enforcement to, you know, we want rules, but the court's giving us rules based on 6-year-old technology. So it really is a hard dance that the court and we have to play.
So following up on exactly on that point of sort of looking forward in terms of the technology and the impact, Justice Sotomayor and Gorsuch both indicated they viewed this case as more similar to than distinct from the Jones case in the key features. So Dan, I'm curious, do you think, did the court err by not taking this more comprehensive question of location tracking generally on when they decided Jones, or was it better for them to wait and take on sort of these types of questions in more bite-sized portions over this long period of time?
So it's always a challenge when a court, you know, has a case before it, an important issue, whether it wants to issue a sweepingly broad ruling or something narrower. You know, that's just a fundamental issue advocates have when we're arguing for the court. You know, should we push broad, push narrow, and the justice isn't deciding it. You know, the court's general tendency is to want to be narrow. It's safer. It is, you know, generally the more jurisprudentially sound or easier thing to do. But sometimes when you go narrow, you leave the public, you leave law enforcement, you leave, you know, interest groups in the like business not having the rule for a large amount of conduct where a rule would be helpful. So, you know, in terms of what they should have done in Jones specifically, you know, in a sense it's hard to answer because what the court did, what happened in Jones was Justice Scalia got 5 justices to announce a new property rights-based approach to what is a search. And having announced that new rule, and 5 justices said that's the rule, and it clearly applied and meant it was a search there, it sort of took all the air out of the room for issuing a ruling that would be more the traditional privacy-based ruling, which would have more sweeping applications, because a case like this, notwithstanding Justice Gorsuch, doesn't really seem like a property-based kind of case. But beyond that, I really do think it would have been wrong for the court in a case like Jones to try to decide the Carpenter issue, right? Because Jones was an issue, as Michael Dreeben said, and trying to distinguish it many times, where the government engaged in surveillance. The government went and they took the, you know, GPS tracker and placed it on the car. The government didn't collect the information in this case. This case involved information collected by the cell phone company, which the government then subpoenaed under the theory that you're equivalent to a witness. Now, one can argue, as Justice Kagan did, as other justices did, as the SEOU did, that that's a distinction without a difference, and that, well, yes, I get it that those are different actions, but at the end, it's the same information being gathered, the same intrusion on privacy, so we should reach the same result. Maybe. The court here probably, it looks like they're going to say we should reach the same result. But it's a different issue, And it just would be wrong for the court in Jones to decide a subpoena case when it wasn't a subpoena case in Jones. So I think that would have been very unusual for the court to reach beyond, reach in a case where it's government surveillance to say, well, let's decide issues that don't involve government surveillance. So we can fault the court for a lot of things, but I don't think we could fault them for not tackling the Carpenter issue in Jones.
And I also feel like it's a bit of a, that because there are these distinct questions, I think that the two stages are kind of important, because in Jones, obviously, one half of Jones is Justice Scalia's property-based theory and how that emerges and how that affects future cases, but also just the recognition in the sort of shadow majority in Justice Alito's concurrence that the, however you want to describe it, some call it privacy in public, or tracking data that would be otherwise publicly observable, is that the Fourth Amendment does have something to say about that. And that came up a little bit in the argument in Carpenter yesterday, but interestingly, it wasn't really a contentious issue, because I think all the justices recognized that the implication of their Jones opinion, especially the shadow majority, was that that type of information, even though someone in public could observe you on a street corner in your car, nevertheless, collecting all those data points as they did in Jones and now as they did in Carpenter is something that the Fourth Amendment speaks to. So now we move on to the second part of the analysis, which is the question about business records. I thought also it was interesting, coming back to Chief Justice Roberts again, that at the beginning of the government's argument, he sort of chimed in early on and said, well, these aren't records simply created by the company. It's a joint venture with the individual carrying the phone. So even, Chief Justice Roberts is really responding to what Dan described earlier as Michael Dreeben's strong opening, saying, look, we've talked about records held by companies for a long time, and the court knows how to speak to this, and Chief Justice Roberts is immediately pushing back and saying, well, is this really like a normal business record? Isn't this different because of the relationship between the user and the company?
And I would say I think there's also the difference, while Jones, which was the GPS tracker put on the car directly, while that could be disposed of as kind of a property trespass matter, the idea that the shadow majority idea of that vast quantity of information is relevant. And I think that's what makes the third-party doctrine particularly inapt here, because you couldn't just call a witness to testify to everywhere you went for 4 months. That would be pretty weird if some person just followed you for 4 months the whole time without having a warrant and being law enforcement. So here, where you have a third party who gets this information, as long as it's accessed by the government, I don't think that the intrusion is any less because it's a third party. In some ways, the intrusion might even be more because it's a third party and is not subject to the checks that the government can be.
Are we just going to be back here again in 5 more years, debating location tracking via new techniques like facial recognition or automated license plate readers? I mean, if we address the sort of actual physical contact in drones, and we're addressing third parties holding records here, what happens when we just have cameras set up that can use an algorithm to map out everyone's location all the time run by the government and don't have either of those issues? Are we just going to be sort of doing this again and again as new technologies come up?
I think that a couple points on this. I think that one thing that will distinguish a lot of future cases, or will enable, I think, lower courts to resolve a lot of these future cases, is the line between what the sort of government is doing directly versus what private companies are doing with respect to users, and then the government is sort of coming in after the fact and getting records from the companies. So I think a lot of the direct surveillance cases, whether it's at the federal or state level, if it involves cameras or direct tracking, things like Stingray cell site simulators or facial recognition by the government, anything involving the government directly, I think is that unlikely to be considered not a search at this point, post Riley, post Jones. But I think that with respect to the commercial application of some of those technologies, I think there was an interesting exchange again between the ACLU attorney named Wessler and I believe it was with Justice Breyer, who was basically saying again that oh, I agree with you on location, but how are the lower courts going to deal with, and it kind of made your point, like the future cases that involve all these different things, and I think, Nate's response was a good one and kind of convinced Justice Breyer somewhat, which is that, well, there are going to be future cases, and he gave a few examples of, different types of data, health app data. I don't remember if he mentioned facial recognition, and he said, these are the types of cases that lower courts are equipped to deal with, and some of them may come back up to the Supreme Court eventually, and you can deal with them at that time. And I think, interestingly, I think that helped Justice Breyer's concern a little bit that this was completely unmanageable, because that's a process maybe he is familiar with. But I don't think it's going to be like necessarily a huge subset of cases that the lower courts just absolutely can't resolve. But there will be a lot of cases, I agree.
Though to a certain extent, I read Justice Breyer's question as being concerned of, how do I write an opinion for you that doesn't call into question everything we've been allowing and that law enforcement routinely relies on? I mean, every day in money laundering cases, bank cases, tax cases, we get bank records, we get credit card records, we get telephone numbers. And how can I write a principled opinion that says, location information, no good, all this other stuff is good? And, I think the answer in the end is they're the Supreme Court. So when they write an opinion that says location information is no good, this other stuff is good, well, that's the law, and everyone will follow it, and life will go on. But I think that, they at least want to take a first stab at being able to say something, something deeply principled as to drawing that distinction, which could actually Justice Alito's first question of, that's pretty sensitive stuff too, that other stuff. So why is this worse? And, I'm not sure one can answer it other than viscerally, and the sense that it feels more like Big Brother when the government knows everywhere we've been, to a greater or lesser extent, back then within a 2-mile radius, maybe today within, a 2-block radius. That's just viscerally more troubling than getting the credit card information. I'm not sure they have more to go on than that, but that's in a sense what the court does in Fourth Amendment cases where, this isn't, there's the reasonableness prong and a lot of Fourth Amendment laws about what is reasonable conduct. That isn't quite this case. This is just, is it a search or not? But in a sense, it's the same thing. The court is just trying to bring its reasoned judgment to bear on a difficult issue and try to balance, the needs on both sides. And one has the sense the majority of the court feels that the balance falls on the privacy side here. They'll manage to write an opinion that says that.
I think that's exactly right. I think there will be a lot of future cases, which I suppose is good for all of us lawyers. But I think that a lot of that will pertain to new technology, thinking about, people who use Alexa or, whatever to, ask Google things. Well, arguably you're giving that information to a third party to do a search, but would we want the government to be able to listen into things that are going on in our houses? And as well, I think similarly, the public-private intersection on so much of this new potential surveillance in the digital age. I think both of those, the technology advances and the intersection with public and private, will be major sources for litigation going forward.
And I forget if we talked about the content, non-content distinction, but, this is so-called non-content data, right? It's just where you were, these points on the map. But what about the text, an email message, what you wrote, what you said, if they could overhear it? There's all sorts of what we might view as content information that you convey on your cell phone and that is somewhere accessible to your cell phone provider. And the government, Mike Dreeben at the argument basically said, we're not arguing content, essentially saying, I heard it as, we're willing to give away content. Now, once you're willing to give away content, then that's a lot of the future cases, right? I mean, a lot of the future cases are matters that I guess if it involves listening into what you're saying in your house, well, that's content, I think. And so I think a lot of the future litigation might be litigation over whether this is on the content side of the line or the non-content side of the line. What is the number of steps you made that your Fitbit records? Is that content, non-content? Probably content, but that might be where some of the battle is.
And those lines are very, blurry. There's a lot of debate in the academic and technical literature over, how you resolve questions like that with new types of data, and even with data that's not that new, like web links and uniform resource identifiers. So when you go to, ABA.com versus ABA.com, or you go to a specific site on a website. You go to Amazon and you browse to a certain item. That's content information about what information you're requesting, as opposed to just information about what web server you're going to. So I think that line becomes increasingly blurry, and whether location information, I guess, in this context, it's being considered non-content. But really where that line comes up, I think that was a weaker part of the government's argument when he got pushed on that point, because the logic of his argument should, in theory, extend to any information held by third parties, and his only real defense when they push back and say, but what about emails, is to say, we don't want to go into content that's been protected forever, which kind of begs the question, I think.
Yeah.
So something very notable to a lot of people watching was that Justice Gorsuch, the only member who was not on the court when it ruled on the Jones case, very focused on property rights, but in a way that he seemed to be implying that a warrant could be required on the basis of the ongoing property rights of the customer, even when the data is held by the phone company, or by what he offered as sort of a comparison to colonial writs of assistance, where you use third parties as agents of the state. Elizabeth, you quoted Justice Gorsuch before. Do you think that originalist judges could make a pro-privacy ruling in Carpenter or in other cases similar to it on the basis of property rights?
So I absolutely think that an originalist argument can be made for Fourth Amendment protections in this case. We made one in the brief we filed with the Cato Institute, so sort of a left libertarian alliance there, and which was adopted in some parts by Chief Justice Roberts' opinion in the Riley case. And I think here you can do the same thing, and our scholars of the original meaning of the Fourth Amendment put forth that originalist case. I wouldn't necessarily say it's the same one that Justice Gorsuch proffered, based on this idea that you have some property rights, I guess, in the records that you're creating. I think the writs of assistance general warrant frame is very relevant for an originalist when thinking about these types of searches and the protection given to our privacy and our liberty. I thought it was actually very amusing that Dreeben started his opening with the idea that technology changes, but the principles don't, which I guess he was thinking of third-party doctrine. We've been talking about these, how these records held by third parties interact with the Fourth Amendment for a long time, but we've been talking for an even longer time about the way that warrantless searches can impinge upon the people's liberty. And when you look at the idea of general warrants, the idea that the government could, mostly using customs officers in the colonial era, could just come in and without a warrant kind of root around and look for evidence of criminal activity, a lot of people see an analog to that when the government can, in this case they had more targeted reasons for requesting that location data, but looking through mass amounts of data could achieve a similar result. You could look for all of the cell phone records for a particular area where there's been a lot of crimes committed and kind of search out the person who maybe was around all of those shootings, for example. So I think that the idea to an originalist is very much one of, is this a search? Looking at the text first, is this a search? And I would say from an original perspective, absolutely, because at the time, search was very much used beyond just the, stepping over the threshold of the house. It was also intended to encompass broader ideas of a search, going out and searching for someone in the town square. So it wasn't limited to simply the house or property. So once you decide that it's a search, then you have to figure out whether it's unreasonable or not. And that's where I think the means by which you collect the data, the amount of the data collected, weighs upon whether or not you need a warrant or not. And I think that the relationship to the idea of a general warrant is something that for an originalist is very compelling.
Yeah, I also think that reminded me, your point, Elizabeth, reminded me also of that moment at the beginning of Dreeben's argument where he said, the legal principles are the same. But of course, the Fourth Amendment legal principles have changed so much over the last few centuries that, if we go back to cases like Boyd and the time when basically the mere evidence rule would prohibit the collection of almost any evidence under the Fourth Amendment, and a time when most of the information about individuals was, not held by a third party, it was held by them, and they couldn't be required to produce it because the Fourth and the Fifth Amendment sort of combined prohibited that. So I think the reality is that the world, not only technology, but the world has changed, and I think that's kind of what the court is grappling with here is, given the changes that have been witnessed even in the last 40 years since Miller, so much is different, and so the implication and the impact of our decision is going to be different, and that's what they're grappling with, I think.
Yeah, I mean, there's a lot to talk about in terms of the property right theory and the originalist theory. The only thing, two quick things. Justice Gorsuch was suggesting that the cell phone user has a property interest in the records created by the cell phone company about the usage. And he was actually making a property argument that I'm not sure the ACLU was making in quite the same way. I think the ACLU is making the property, he was basically saying that there's a literal property right because there's a statute which says that the cell phone company is limited to whom they can give the information to. And I should say, I guess the ACLU is using that statute in a somewhat different way, saying that statute creates an expectation of privacy. So they were using the statute, I think, really to help their reasonable expectation of privacy argument. Justice Gorsuch took it and used it to create a property right argument. I essentially have a property right that's created by dint of the limits on the cell phone provider's use of it. And it's fascinating to Justice Alito and Justice Gorsuch really having a back and forth. So it's two conservatives on the court with very different views on that issue. And Justice Alito, to give a helpful question to Michael Dreeben, to say, are you familiar with any other kind of property which the customer can't make you create, can't stop you from destroying, can't stop you from doing a list of things, into which Michael Dreeben said, I'm not aware of any other property of that sort. I don't think any other justice on the court, though it's always possible Justice Thomas will buy into that, but I'm not even sure and Justice Gorsuch will ultimately write a separate property opinion. We'll see.
Just a quick additional point on that. I thought that on rebuttal, the ACLU did a good job of coming in and speaking to this point a little bit and saying, look, just because you don't have, property rights, we think of, and even said specifically mentioned the bundles of 6 point, just because you may not have all the bundles, you do actually, under the statute, have, the right to exclude, the right to determine the use of the data. He mentioned specifically, and this is under the Telecommunications Act. So, a quick aside here, this came up in the discussion, especially between Justice Gorsuch and Justice Alito, and they were talking about Section 222 of the Telecommunications Act, which regulates the protections for the privacy of customer information. And the phrase that they both were sort of talking about, but neither of them were particularly familiar with because they're not telecom lawyers, is a phrase in 222C, which is confidentiality of customer proprietary network information. And I think Alito actually got this wrong in the argument where he said, well, he asked, kind of formed as a question to Dreeben, well, doesn't proprietary mean it's proprietary to the phone company? And it kind of went on along in that vein to say, doesn't that actually prove the point that he had made earlier that it's really the phone company's data? And even Michael Dreeben had to say, actually, I don't think that's what the statute says, and it doesn't. Interestingly, if you look at 222, there's a distinction between carrier information and customer information, and I think it reinforces the point that even Justice Roberts acknowledged that this is different than a normal business record. There is a explicit recognition in positive law passed by Congress that this is a special category of data that is not just sort of the phone companies to do it as it pleases.
So we've talked about that. It seems, some mystery on where and how exactly they'll land, but the Supreme Court overall, they seem very sympathetic to Carpenter's side of the case. A lot of lower courts have not. There have been a huge number of lower courts that have ruled that this type of cell site location tracking doesn't require a warrant. In fact, 4 circuit courts have ruled definitively on this matter. All four have said that cell site location tracking should not require a warrant. Then why does the Supreme Court seem to be so diametrically opposed to where many of the lower courts have landed on this?
Yeah, I thought about it a little. I think it comes down to the Supreme Court, the different places they have in our judicial hierarchy. You've got existing doctrine, the third-party doctrine, which seems sort of on its terms to apply here. And I think a lower court generally feels that it's not really its place to say, well, given the sensitivity of this information, I'm going to need, a district court, a federal court of appeals are going to create a new exception to this doctrine, even though it seems to fit within it, but I'm going to create this new exception. It's just, some will do it, and some, I guess, lower courts have done it, but I think there are many judges who feel that's not appropriate for it. I mean, if there's going to be a newly minted exception based on sort of policy grounds, concerns that I have, sort of value judgments about saying that, well, this is a greater intrusion of privacy than this other, right? That's for the Supreme Court to do. And of course, it looks like they may well do it, but my sense is that's really what's happening. They're the Supreme Court, and they get to do these things. Arguably, it's not for the lower courts to, create new exceptions.
I think that's exactly right. I think the lower courts just don't want to break new ground, and they want to leave it to the Supreme Court. I guess you could have, done a Judge Neil Gorsuch and written your majority opinion saying one thing that's conservative and goes with the Supreme Court precedent, and then writing your own concurring opinion to your majority opinion saying, like, well, we should rethink this whole doctrine, which he did in a couple cases where he had some theories when he was on the lower court of appeals. So now I guess he can freely talk about them now that he's on the Supreme Court bench. But I'm not surprised that the lower courts generally didn't want to break new ground.
But it is interesting that they were, it was not easy. Even with the lower courts, the federal appellate courts ultimately being unified on the point, which is one of the reasons why the grant of cert in this case was so significant. There wasn't a split in federal appellate courts, but there was a significant dispute because there were in a number of circuits, there were first panel opinions that ruled in favor of the defendant, saying there was an expectation of privacy, that then those cases in the 11th Circuit and the 4th Circuit both went en banc and were overturned with dissents from judges. So I think there was, a significant noise being made that the court realized it was kind of time to take this up and resolve it once and for all.
And also, in addition to those cases, a number, I think at this point, somewhere in the range of 12 to 15 states that have enacted statutes effectively putting a warrant for location law into effect. Obviously, that applies to the states, not to federal law enforcement actors, but there is already sort of a rumble in a variety of ways. I have several more questions I'd love to ask, but I do want to make sure that we have plenty of time for any audience questions. So I'll now kick it off to the audience here, and also, as we said before, anyone watching the webcast can submit questions that they'd like to ask to our panel.
I'm not sure. Do we have a microphone? Do we have a mic? If not, I can also repeat the question. So,
please compare evolving technology with evolving standards of decency. If we were talking about cruel and unusual punishments, we'd be talking about the Supreme Court talking about a value issue, evolving standards of decency. This is evolving technology. It's an empirical question. So what are the similarities and differences from your deep thinking, wonderful panel today? Think some more, please.
Yeah. So the question was, we have this case obviously deals with evolving technologies. The Supreme Court also in other non-Fourth Amendment cases has dealt with evolving standards of decency, and sort of how do we contrast these different treatments by the Supreme Court of these evolving issues that come before them. I think the empirical basis of a lot of these technology-based cases is very fascinating at the court, both because of the issue we talked about earlier, where there's always this time lag, and the court is always wondering, when it's too early to step in, are we too late? But also another issue that is always interesting for me as someone who writes amicus briefs, which is what is the influence of the amicus and outside sort of bar on the court when they're getting, as in this case, a number of briefs from even briefs, from technologists, briefs from interdisciplinary researchers, and how they grapple with that. I think in Riley, Justice Roberts really did embrace that sort of broader view of the scope of, or the sort of context of what he was doing, to say, I need to understand what impact cell phones have in people's lives, how they're used. I mean, he famously asked at oral argument, why someone would have more than one cell phone if they weren't a criminal, right? But I think that he learned from that. I imagine that he went back and his clerks probably had to inform him that they had more than one cell phone because they worked for the government. So I think that in technology cases, and Jake alluded to this earlier too, that the court really has stepped up its game, and in part I think it's because that they're doing the work to understand, probably as they do in these other types of cases, to really understand the context of their decision in the case.
Yeah, I think, there are places where the drafters of our Constitution use language that, as a textualist, certainly does allow for expansion, and I wouldn't say expansion, I guess evolution is perhaps a better way of looking at it. So we talk about what's unreasonable under the Fourth Amendment, and they specifically used a word like unreasonable, which can be subject to different definitions over what's reasonable. And when you have something new come up, then I think you look at various factors of what is an unreasonable search, and that includes the means of gathering information, the type of information gathered, what can be done with it. And could also include all these other doctrines that the court has created to try to figure out what unreasonable means. I think that the idea in the Eighth Amendment context about cruel and unusual, Justice Scalia pointing to the fact that, flogging was acceptable at the time of the founding, I think that's an overly cramped originalist view of the Eighth Amendment, just in the same way that if you, refuse to take the language of the Constitution and apply it to current values and conditions, would just be a silly way of having constitutional interpretation. The point is that you look at the text, that is where you start, but you don't read limitations into the text that aren't there.
Yeah, my very quick reaction is that they might be almost opposite endeavors, in that with the Fourth Amendment and evolving technology, you sort of have the Constitution tries to create a certain amount of privacy, protection from the government, and the goal is to stop this new technology from destroying that and from, poking holes in it. So you're trying to sort of preserve that original amount of privacy from this new stuff. Whereas the evolving standards of decency is saying, over the protest of Justice Scalia and Thomas, we're recognizing that what was protected is changing. It's evolving, and so maybe flogging was okay at the beginning, but now it's no good, and so you're actually changing what is constitutionally protected. So I said maybe they're sort of quite different inquiries.
Other questions in the room, and go to them. Yeah.
Are we looking here at like a whole-scale rewrite of the reasonable expectation of privacy test? I mean, you can see that as sort of a construct on what is an unreasonable search procedure in the Fourth Amendment. Then the third-party doctrine is a construct on top of that to determine what is reasonable. But I sort of know when I hold this and I carry it around, I have no reasonable expectation of privacy in basically whatever I put on here, whether or not I cede that to a third party or not. And so it seems to me that just the third-party doctrine is taking a lot of shots here, but just might be the first domino to fall before we have to rethink the reasonable expectation test sort of writ large.
So the question is, is this case going to spark basically a complete rethinking of the reasonable expectation of privacy test? Can it be decided narrowly, I guess, is part of the question. I think that to me is the thing the court was really grappling with. I think that the court feels, again, the justices sort of feel a consensus around the outcome in this case in terms of whether, whether the Fourth Amendment has something to say about tracking someone's phone location over time, but they're trying to figure out, well, if we write this opinion, does it blow up Smith versus Maryland and Miller, and does it blow up a bunch of existing activities that are currently regulated in a particular way, and how do we resolve this? I think it's interesting to think back to to the Berger decision, which predated the Wiretap Act, at which time, in many states, listening in on conversations, even for the police, was illegal. In other states, it was authorized, for example, with a warrant. So in New York, in the predating the Berger case, they were listening in on people's conversations with a warrant, and the Supreme Court overturned that and said that was a violation of the Fourth Amendment. That was unreasonable, and actually laid out basically the factors that ended up getting codified into law by Congress in the Wiretap Act, and said, look, here's what you need to consider above and beyond just whether there's probable cause in a case where you're listening in on private conversations. And I think it's interesting to see Justice Sotomayor, and in the early questioning in the case, sort of asking these questions about, okay, well, what about all the calls from a particular tower at a particular time, where we're not targeting an individual, but we're targeting a place and time, or what about, she's calling them incident versus dragnet-based searches, and I think is maybe starting to tease out some ways that the court could write an opinion that pretty clearly says to Congress, hey, here's some things you could consider when you do some regulations around these types of searches. So I think it's possible we could see a decision by the court that prompts legislation by Congress as Title III was developed.
Yeah, I could see the decision perhaps changing the contours of the third-party doctrine, which is one slice of the reasonable expectation of privacy doctrine more broadly. I don't think this case will be a vehicle to revisit the reasonable expectation of privacy doctrine more generally. It's a complicated doctrine, and Professor Kerr has written that really there are 4 different ways by which the court has sort of interpreted that doctrine, and it seems to pick and choose in each case. Perhaps in some case in the future, the court's going to try to come up with its own unified field theory of what truly is a reasonable expectation of privacy. I don't think it's going to do it in this case. I'm frankly skeptical it's even going to try to do it in a future case.
I think that in some ways, I totally agree about it not happening in this case. But in some ways, I do see it as a really serious issue as we look down the line to other technologies like facial recognition, and also generational shifts. I think that when you talk about how you don't expect anything on your phone to be really private, I think there are a lot of people who, especially older folks, who are like, oh my God, of course, it's private, or you can't look in my home. And people are like, oh, I did a web stream of my life for 24 hours. So I think in some ways it's the expectation of privacy in digital communication. Ironically, I think some of the younger folks have less of a privacy impulse. Then I think that implicates the question of, well, if we put more of our lives out there, can we change the Fourth Amendment protection of privacy by not expecting privacy? And that's where I think the fact that the Fourth Amendment uses the right of the people is important, because it's not necessarily just whether you think it's private or not, but, and of course the reasonable expectation of privacy doesn't just rely on an individual subject of opinion, but does this change the relationship between government and citizen? And I think a lot of us might be willing to give up privacy if we think it will help catch terrorists. Maybe privacy interests in our, in facial recognition or in other digital communications. But is that something that we can do? I think of this poll that we at the Constitutional Accountability Center did, and we asked people about the travel ban. And we said, do you think this is a Muslim ban? And the majority of people said yes. And then the next question is, do you think it's unconstitutional? And a lot of people thought that it was both a Muslim ban and constitutional. And just because you have people taking a view of the Constitution one way or another, that doesn't mean that the right doesn't exist. So I think particularly in privacy cases, and because we have this reasonableness idea, if people are willing to give up their privacy, and probably people like Alan will be advocating for why they shouldn't, it does create some very interesting and to me problematic implications for the relationship between the government and the governed.
And I also think that the privacy fatalism, which comes up sometimes, that is a bit tech deterministic. People worry. You read a lot about data breach, or you read about a new piece of technology or a new piece of malware that allows a nefarious person to get into one device or another. I think there is a strong distinction between, what technology could potentially allow a nefarious person to do and what the Constitution permits the government to do. And actually, the Fourth Amendment is not doing any work at all if it's just the case that, well, if the government has the technological capacity to do this, then we have no right to prevent the government from doing it. Then the Fourth Amendment is a dead letter. So I think, kind of to the point Dan was making before, like there's always this evolving dynamic where technology is increasing not only what we can do, but what the government and what others, including criminals, can do. And the court's job is in this context is to grapple with the Fourth Amendment and say, okay, how do we ensure that the people are secure in their persons, houses, places of their effects, in light of the government's capabilities of these technologies and the technologies that people are using. So I think that's really the question they're grappling with. Great. Do we want to do a call? Yeah, Paul, do you want to do a call from the webinar? Or question? Yep. Okay, so the question is it, and I assume the it here is the tracking of the phone, is it unconstitutional currently to track cell phones with a warrant, and how does this affect custom searches? So to the first point, the lower court in this case, the Court of Appeals, in this case in the Sixth Circuit and also in a number of other circuits, had previously held that it was not unconstitutional for the government to collect this data, and the government is doing the collection pursuant to this statute, the Stored Communications Act. So for those who are not sort of familiar with the background in this case, Congress passed a law in 1986 regulating the collection of information. At that time, that was about stored communications, but really before the internet existed, and also had to do with phones and other telecommunications equipment. And so part of that law, called 2703D, is the sort of key issue in this case, which is a law that authorizes the government to get call detail and related information from a provider, like a phone provider, if they go to a court with specific and articulable facts to show that the information is relevant. So it's not a probable cause standard. There is a judge involved, and so far the federal courts of appeals have held that is constitutional, citing these two key decisions we've been talking about, Smith versus Maryland and Miller versus United States. So if the Supreme Court says in this case that it is unconstitutional, then there will be a whole other series of litigation about what that means about current cases, and then it'll apply to future cases and everything there.
Which connects to Justice Alito's final question, pretty much when the red light was on for Nick Ressler, which was, how is this going to help your client? Because under existing doctrine, if the police acted in reliance on a statute that wasn't obviously unconstitutional, then the sort of good faith exceptions to the exclusionary rule applies, and the evidence could still come in. Nate Gamely said, well, there are a couple of ways they might try to say that they don't fall within that. As a practical matter, I think there's no way Mr. Carpenter gets relief, and probably most folks who have been subject to these sorts of third-party subpoenas, and it's been used in their cases, will not get relief from this. But of course, it'll have very important effect prospectively.
That's always the bane of the appellate lawyer, is you win this really important victory for some constitutional right, and then you have to tell your client that yeah, it means a lot for future criminal defendants, but nothing for you. So I think that probably is unfortunately the situation that Mr. Carpenter will be in.
There's a really complicated saga, as I recall, on remand in the Jones case. I think there were like several mistrials, and I actually don't even know in the last iteration whether the prosecutors decided to bring it to trial again. So that case was a very complicated answer of what happens next, and that's just one example. Great. Do you want to do another one more from the? Great. So the question is the Supreme Court or are the courts of appeals considering the international rights implications of their decisions when they're judging these questions? Someone else want to?
That's that's a great question. I don't know, I haven't read all of the amicus briefs, but I don't know that that has come up, but it might just be in one that I haven't read. But I'm sure that Justice Kennedy and Justice Breyer would probably love to consider the international law implications of the cell site location tracking. You know, I do think that in some instances, maybe not in this one, but when you're talking about surveillance, you can't help but think of the way that this might look to other nations. You know, we certainly, used to care about the way that we were held in regard by the international community, and generally in democracies, we don't spy on our citizens. So, you know, to the extent that is there as a background, I think the international human rights implications are sort of there as a background, but I don't know that they were explicitly argued in this particular case.
Yeah, I don't think they were, and I think when the court is answering the Fourth Amendment question specifically, they don't necessarily import those concepts, but they are relevant and at play in a lot of Fourth Amendment cases, including in a big case coming up this term, which is Microsoft versus the United States, which involves requests basically by the U.S. government for data from a company in the United States. Microsoft, the data is actually held abroad in Ireland and is data of a non-U.S. person. So there are significant, especially increasingly where everything is international and data really doesn't necessarily follow or track national boundaries. There are increasingly important international implications for these questions.
Correct me if I don't have this quite right, but I believe Congress, when it does consider international treaties, human rights treaties, things like that, takes them as equivalent of statutory measures. So even if a case like this were decided on the basis of international human rights, Congress would still have the ability to preempt that ruling with any sort of statute of its own passed after that. It would kick the ball to Congress to take that type of action, but it would not have the same type of force that a constitutional-based ruling would have, that Congress doesn't have the power to overrule. They simply have to accept. Right. Do we have any other questions?
And that was wondering why no other kind of safeguards were considered by the court, and nothing was said about that. Yeah, because this was said about comparison with the constitution and the statute. It was not discussed that much. For example, think about other safeguards such as the notification of the money.
So the question, the audience member noted he's from France, and the question is, why is the Supreme Court in the U.S. Focused so much on these questions about, probable cause in the warrant context, the reasonable expectation of privacy, potential exclusion of evidence? Why not focus on, some of the other additional safeguards? It's interesting. I noted earlier the Berger decision, which was way back in the 60s and predated our current Wiretap Act. But what was so fascinating about that case is that it was the precursor to what we call the super warrant standards. So a lot of searches in the U.S. are decided on the basis of probable cause, particularity, sort of scope of the search, and then whether that either of those provisions was violated. Notice is involved also in the warrant process, but in certain cases, including in the case of a wiretap, actively listening to a conversation, there are additional requirements that the court did impose. The Supreme Court imposed in the Berger case, and could do so again if it felt that a particular search was so invasive as to warrant those type of additional protections. So the court does have that power and can speak in those terms. It just doesn't do so in many cases, and a lot of times in the U.S. it's because there's actually a statutory structure that Congress has passed to address particular issues. So what's a little bit different in this case is that under the ACLU's form of the argument, Congress never really addressed in the current law how location data should be obtained. And the government's position is basically that, well, under the current law, location data can be obtained even if Congress didn't speak to it specifically. So that's why we're kind of in this situation.
Yeah, I'm not sure how many other countries have the exclusionary rule. I think few do. And of course, that means that, you know, the interpretation of the Fourth Amendment, depending on how the case comes out, will lead to a conviction being overturned. And so we just have, you know, a extraordinary number of cases where that's the issue. But, you know, from a different perspective, I think part of the government's argument is to look at other institutional reasons why we should take comfort that these rules won't be abused. You know, I mean, some of them are legal, non-institutional, sort of the legal limits on when you could issue a subpoena generally, relevance, overbreadth, that sort of thing. Then the statutory limits that are under the Stored Communications Act. And then you have sort of the practical ones. I mean, you know, there are resource issues. When you get one of these, try to issue one of these third-party subpoenas, you know, they don't just say, well, who's someone I don't like? Let me see if I can get a year's worth of records about them and see what I can get. You know, they have professional obligations. They have professional responsibilities. They could be subject to damages if they do these things unlawfully. They have time constraints. You know, they generally, you know, there are always rogue officers or rogue prosecutors. I'm not saying they don't exist, but generally there are real-world constraints that limit them to trying to get this information in connection with a genuine criminal investigation. Now, that doesn't help Mr. Carpenter's having his privacy intruded for 127 days. But just in terms of when the government is trying to explain why, you know, we shouldn't be too unduly concerned about the potential, you know, parade of horribles that, you know, the other side is trying to convey, those are certain arguments that we will generally try to make.
It can be especially relevant to, as we discussed, cases here involving a third party, because we have an individual receiving an order. The basis of the law is what lets them either say, throw up their hand and say, well, there's nothing I can do, this is the law, or potentially object to it. Right.
Yeah, I think Justice Alito at least would, from his concurring opinion in Riley, which said, hey, you know, we should probably kick this to Congress. You know, I concur in the ruling because what else am I going to do? But, you know, it would be great if Congress would weigh in with legislation here. And, you know, maybe they will. I think certainly the government argues that the existing law does provide adequate safeguards, even if it doesn't rise to the standard of showing probable cause. And just to nerd out for a minute, there is an argument that the exclusionary rule is not, as a matter of original meaning, required by the Fourth Amendment, that instead you should basically get rid of the developed doctrine of prosecutorial immunity and allow people who've had unconstitutionally gathered evidence used against them in court be able to sue for damages and civil rights violations.
Will you be filing an amicus brief to that effect?
Any additional questions?
One of the additional points actually makes it relevant to this question is that, and I may have mentioned this earlier, but I do think that we may see some of the justices in this opinion, especially if there's concurring opinions, speak to some of what they might envision maybe being, you know, statutes passed by Congress or being factors that need to be considered in future cases. One thing I mentioned was Justice Sotomayor's reference about, you know, different types of location searches, like the use of, you know, dumps of data from a single tower at a single time. And I think one thing that I found interesting that came out of that discussion and oral argument was really a focus on scope and how, you know, if you were to form it as a question about what is wrong with the current statutory structure, because obviously the government does take the position that it's sufficient, and Mr. Dreeben focused on the fact that there's a judge involved, which is true. The standard is lower than probable cause, which is one issue, but I think the more significant issue is that there's no scoping whatsoever, right? The standard is not probable cause of evidence of a crime, it's relevance to the crime. There's no specificity required at all. I agree that it's the case that the prosecutors, you know, generally are not going to go and just collect everything, but in a lot of cases, even in cases where there are warrants, they always go for the larger set rather than a more narrow set, maybe in part because they know that the judge might push back inherently and sort of like meet in the middle. But I think the justices seem to sort of key into the fact that there should be some, more narrow focusing of what's being seized here if you're getting this type of sensitive data.
So along those lines, actually, I'm curious. If we presume it's likely that there's some sort of warrant requirement for individual cell phone tracking as a result of this case, as you're discussing, we have other types of cell phone tracking, cell tower dumps where you get every cell phone connected to a cell tower for a time, stingrays, which these devices that effectively imitate a cell tower and suck up every cell phone in the area, dirt boxes, which are basically stingrays on a plane that fly around and suck up thousands, even tens of thousands of phone location data. And should we have a greater level of scrutiny for those types of things, and if so, what should it be?
Yeah, I think I think that tower dumps are a really different use, an example and use of the technology than are the tracking of an individual phone over time, and there very well may be a different rule. That seemed to be what Justice Sotomayor was implying, and I think that makes some sense. And on the flip side, so I could imagine a scenario where you have a lower standard for something like a single point in time collection of data, but with a strict, let's say, after the fact minimization, because what's going to happen with a tower dump is you're going to get everyone who's connected to a particular cell phone tower at a particular time. Now, there may be a very close nexus between that and the event that's being investigated, but the scope of number of people whose data is being collected is very broad. So there may need to be some rules about, if that thing is collected pursuant to a court order or whatever it is, maybe it's more important what happens next rather than what the standard is to get that. With stingrays, which is an example I mentioned earlier, the device that an individual, the government could use to do all sorts of things, but is in particular used to triangulate a phone without even going to the phone company. But it could also be used to intercept content and to do a man-in-the-middle attack. I think the more advanced technologies like that may actually require that type of super warrant level of scrutiny that is the case for wiretaps, and I think there may be other examples in the future that require that too. So we may be looking at a greater sort of filling in of levels of scrutiny in future cases, either under statute or potentially under the Fourth Amendment if courts decide that, in certain cases a warrant isn't enough.
Any other questions from the room or from our viewers online?
No? Yeah.
So there's the Microsoft case later this term, and it differs from Carpenter in a lot of important ways, but it's similar to others. Was there anything that happened during Carpenter that you think gives you clues or insights as to what's going to happen during Microsoft?
So the question was about the Microsoft case, which, as I mentioned earlier, is coming up this term and has to do with searches of data held abroad. The question was whether there's anything that happened during this argument that had any sort of potential impact on the Microsoft case. Nothing immediately comes to mind for me. I don't know what others think of.
Yeah, I thought I vaguely remember Justice Gorsuch saying something that made me think, oh, that maybe isn't great for Microsoft from the government side, but I'm not sure which of his various theories that might have connected to. I'm not sure if it's property right view, therefore, yeah, I'm not sure on the connecting the dots right now.
I mean, certainly if he thinks that all subpoenas are equivalent to writs of general reform, then that's cause an issue, but
that could be it. Yeah, I mean, his reasoning right basically is that all subpoenas or all third-party subpoenas for customer information are searches, of course.
I mean,
right, and of course at Microsoft it's based on probable cause. So
yeah, I think the issues are distinct enough that the overlap may not be huge here, just because it's a statutory question in Microsoft and it's an extraterritoriality question, and so the court's going to be asking very different sorts of questions, but similarly large impact. So great. Well, I think we may wrap there, so we have some time after the panel, unless you want to do one parting question.
So Justice Alito in Jones raised this sort of scenario that I think Elizabeth, you also raised, where a cop follows you around for 127 days, and it just doesn't happen because it's resource constraints. It seems to me that the constraint there is resources, that wouldn't require a warrant. The cop could do that, but the reason they don't do that is because they don't have the time, money, or effort. That seems to be a resource constraint, not a constitutional constraint. And how does that impact this decision here? So what we're talking about is a constitutional restraint, whereas it seems like you get the same data without a warrant under existing law. It's just based on following the guy, and the only reason that doesn't happen is time.
Yeah, I think in Jones, they talk about the idea that it is resource constrained, and in some ways that plays into the reasonableness of a particular search without a warrant. There's just the simple fact that you couldn't have someone following you for that period of time. It's just not going to happen likely. And so that's why the means of evidence collection comes into play, because once the government has the ability to have mass data collection very easily, then whether or not when that becomes a much more prevalent way of getting information about people, then I think that changes the reasonableness.
Yeah, that was the government's argument in Jones, right? You're in public, you have opened yourself up, you don't have privacy, you could be followed, whether it's for 1 hour, 1 day, 127 days, or whatever, 60 days in Jones, 30 or 60. But the court, recognized, the logic sort of holds. That's where sort of what was called the mosaic theory came in. Sort of, but we know realistically that's not what's happening, and they made a judgment call.
I also think, one version of one answer to that is that's what the reasonable expectation of privacy test is. That's the question it's answering, is whether it is reasonable to imagine that this sort of search could happen. And I think Justice Alito is basically saying in Jones, no, it's not reasonable to imagine that that the police would invest the resources to follow an individual around for 6 months or 4 months or however long it is. And that's an indication that there is an expectation of privacy as to the collection of that kind of information.
Though Nate was being asked that, I think one of the questions, and I forget who it was from, said, I think it might have been from Kennedy, was saying, so it's okay if the police officer follows you for 127 days, but it's not okay for the 127 days from the cell phone. And he seemed to accept that.
Right.
Yeah, the police can follow you for 127 days, they're just not going to. So it's interesting, there's a slightly different take on it than that it actually wouldn't be okay for the long period of time.
The other thing I thought was interesting in the line drawing conversation was, obviously the ACLU is getting a lot of pushback, 24-hour rule, or how do you draw the line on the short side, right? 127 days is a search of what about 10 days or 1 day or an hour. But Kagan flipped it around on Michael Dreeben, and she said, well, what about forever? Right? Where's the line in the other direction? So can they just track you forever? And he said, well, of course not. That would be something all this like great. Would it be relevant? But where's the line? There's the line drawing up direction too. If you allow 107 days, do you allow 300 days? Do you allow 1,000 days? Forever. So I think that they're finding both directions here. So, but they have to draw a line. That's where we end up.
Well, thank you so much for everyone who came out to attend this event. Thank you to all panelists. This was a fascinating discussion. I think we all definitely eagerly look forward to where this decision lands and all the thoughts and reactions that come out when we have a ruling.
Great.
Thank you very much.
Well, thank you.
Thanks.